Hello बच्चों, let's see passage number 2. Passage 2 says about contracts form the backbone of business transactions serving as legally binding agreements between party. Contracts क्या होते हैं? Contracts होते हैं legally binding agreements between the parties. However, there are instances when unforeseeable circumstances arises that render the performance of a contract impossible और impossible हो जाता है या fundamentally different from what was originally intended. अब ये बात करते हैं अनफोर्सीन सर्कमस्टांसेस की. अनफोर्सीन सर्कमस्टांसेस क्या होते हैं? अनफोर्सीन सर्कमस्टांसेस वो सर्कमस्टांसेस होते हैं जो अगर पार्टीज जब कॉन्ट्रैक्ट में एंटर कर रही है तब वो फोर्सी नहीं कर पा रही है, तब उनको समझ नहीं आ रहा है कि ऐसी भी कोई सिचुएशन हो सकती है जिस वजह से कॉन्ट्रैक्ट का इन स्पेसिफिक टर्म्स पे कंपाइल होना पॉसिबल नहीं होगा. So this situation is known as frustration of contract, possesses unique challenges for parties involved and requires a careful examination of legal implications. तो ऐसी situation को हम क्या बोलते हैं? ऐसी situation को हम बोलते हैं frustration of contract. In this article, we will explore the concept of frustration of contract, its causes and its potential consequences it can have on contractual obligations. The frustration of contracts refers to a situation where an unforeseen event occurs, rendering the performance of a contract impossible. अब ये अनफोर्सीन सर्कमस्टांस तो हो रही है, अब इसकी वजह से जो परफॉर्मेंस ऑफ कॉन्ट्रैक्ट है वो कैसे अफेक्ट हो रही है? तो वो ऐसे अफेक्ट हो रही है कि या तो उसका होना इम्पॉसिबल हो गया है, इलीगल हो गया है या फंडामेंटली डिफरेंट हो गया है from what the parties initially anticipated. This event must occur after the formation of contract and must be beyond the control of parties involved. तो दो यूनिक क्राइटेरिया क्या है कि ये सबसे पहले तो आफ्टर होना चाहिए, after the formation of the contract, and it must be beyond the control of parties. Okay. Common examples of events that lead to frustration of contract includes common examples क्या क्या है? सबसे पहला is natural disaster. अब natural disaster parties के कंट्रोल के बाहर है, वॉर पार्टीज के कंट्रोल के बाहर है, गवर्नमेंट रेगुलेशन अगर अचानक से आ जाती है तो उसमें पार्टीज का कोई कंट्रोल नहीं है. अगर डेथ हो जाती है या इनकैपेसिटेशन हो जाता है की पार्टी का, तो ये सब सिचुएशंस फ्रस्ट्रेशन ऑफ कॉन्ट्रैक्ट्स की तरफ चली जाती है. When a contracts become frustrated, the parties are relieved from their future obligations under the agreement. अब ऑब्वियसली अगर कॉन्ट्रैक्ट फ्रस्ट्रेट हो गया है, मतलब कॉन्ट्रैक्ट का होना इम्पॉसिबल हो गया है, तो आप कोई फ्यूचर ऑब्लिगेशंस तो बचे ही नहीं है पार्टीज में, मतलब कॉन्ट्रैक्ट कैंसिल हो गया है. दिस प्रिंसिपल इज नोन एज द डॉक्ट्रीन ऑफ फ्रस्ट्रेशन. इस पूरे प्रिंसिपल को हम बोलते हैं डॉक्ट्रीन ऑफ फ्रस्ट्रेशन. Recognizes that it would be unfair to hold parties accountable for circumstances beyond their control. However, the consequences of frustration can vary depending on jurisdiction and the specific terms of contract. Now let's see टर्मिनेशन और डिस्चार्ज. अगर टर्मिनेशन है तो कैसे होगा और डिस्चार्ज है तो कैसे होगा? फ्रस्ट्रेशन टिपिकली लीड्स टू ऑटोमेटिक टर्मिनेशन. फ्रस्ट्रेशन से क्या होता है? फ्रस्ट्रेशन से कॉन्ट्रैक्ट ऑटोमेटिकली टर्मिनेट हो जाता है. द पार्टीज आर रिलीज फॉर देयर फ्यूचर ऑब्लिगेशंस. पार्टीज के ऊपर कोई भी फ्यूचर ऑब्लिगेशंस नहीं रहते हैं. एंड द राइट्स एंड ऑब्लिगेशंस दैट हैव ऑलरेडी अक्रूड रिमेन एनफोर्सिएबल. जो ऑलरेडी अक्रू हो चुके हैं, जैसे अगर मैंने कोई गुड दे दिया है पहले ही अनफोर्सीन सर्कमस्टांस होने के, तो अब वो पैसे मिलने मुझे, वो मेरी राइट है जो कि ऑलरेडी अक्रू हो चुकी है और सामने वाला को ऑब्लिगेशन है कि उसे मेरे को पैसे देने पड़ेंगे. तो ऐसे केस में वो राइट एनफोर्सिबल रहेगी. In some cases, the parties may need to formally communicate the frustration to ensure clarity and avoid disputes. अब यहाँ पे कीवर्ड है कि in some cases, so this is not an obligation कि formal communication होना जरूरी है, but अगर formal communication होता है तो it's better, or it is the requirement of some cases. Second is allocation of losses. अब allocation of losses कैसे होगा in case of frustration? The question of who bears the losses arising from the frustrated contract is a complex issue. Common law jurisdiction often employs the principle of loss where they fall. अब ये प्रिंसिपल क्या है, लॉस वेयर दे फॉल, लेट्स सी, मीनिंग ईच पार्टी बेयर देयर ओन लॉसेस। बहुत सिंपल सी बात है कि जो पार्टी को जो लॉस हुआ है वो पार्टी खुद अपने लॉस को बेयर करेगी। हाउएवर statutes or specific contractual provisions may allocate the losses differently. It is crucial to consult legal advice to understand the applicable rules in a given jurisdiction. अब third is restitution. In case of frustration, restitution may come into play. Restitution allows for the recovery of any benefits conferred before the frustrating event occurred. अब benefits conferred before the frustrating event occurred का मतलब क्या है, इसको एग्जाम्पल से समझते हैं. If a payment was made under the contract but the performance became impossible, the party who received the payments may be required to return it. बहुत लॉजिकल सी बात है कि अगर मैंने आपको पेमेंट कर दिया है लेकिन आप अपने परफॉर्मेंस नहीं कर पा रहे हैं ड्यू टू द इम्पॉसिबिलिटी ऑफ द परफॉर्मेंस, तो आपको वो पेमेंट मेरे को रिटर्न करना पड़ेगा. वेरी सिंपल. लेट्स सी पॉइंट 4 दैट टॉक्स अबाउट force majeure clauses. What is force majeure clauses? Let's see. Many contracts include force majeure clauses which allocate the risk of unforeseen events between the parties. These clauses typically list specific events that, if they occur, would excuse performance and provide alternative remedies. तो बहुत सारे कॉन्ट्रैक्ट ऐसे होते हैं कि वो फोर्स मेजोर क्लॉज ऑलरेडी अपने कॉन्ट्रैक्ट में इनकॉर्पोरेट कर देते हैं और उससे बता देते हैं कि भाई अगर ऐसी सिचुएशन हुई तो इस सिचुएशन में हमारा परफॉर्मेंस जो है वो एक्सक्यूज हो जाएगा और ऑल्टरनेटिव रेमेडीज मिल जाएंगी. हाउएवर द प्रिसाइज लैंग्वेज एंड इंटरप्रिटेशन ऑफ फोर्स मेजोर क्लॉसेस कैन सिग्निफिकेंटली इम्पैक्ट द आउटकम इन द फ्रस्ट्रेशन केसेस. The frustration of contract is a legal concept that acknowledges the impact of unforeseen circumstances on the performance of a contract. So frustration of contract एक ऐसा legal concept है जो frustration of contract in the case of unforeseen circumstances को acknowledge करता है. It provides for mechanism for parties to be relieved from their obligation when the performance become impossible or fundamentally different due to events beyond their control. Understanding the legal implications of frustration, including termination, allocation of losses, restitution, and the role of force majeure clause, is essential for parties navigating such situations. Consulting with legal professionals can help parties assess their rights and responsibilities when faced with a frustrated contract, ensuring a fair and equitable resolution in light of unforeseen circumstances. Now let's see questions. Question number 6 says two parties, company A and B, entered into a contract for the delivery of goods. However, due to an unexpected earthquake, the transportation route between their locations became completely impassable. As a result, company A was unable to fulfill their delivery obligation. Which of the following options correctly applies the frustration of contract based on the information provided? तो इस केस में बोल रहा है कि कंपनी जो कंपनी ए थी वो अपनी फुलफिल नहीं कर पाई ऑब्लिगेशंस ड्यू टू वन लोकेशन ऑफ द ट्रांसपोर्टेशन बिकमिंग कंप्लीटली इम्पॉसिबल. तो इस केस में क्या इंफॉर्मेशन के बेसिस में फ्रस्ट्रेशन होगा? Let's see option number A. A talks about company A and B must renegotiate the terms of the contract to accommodate the unforeseen circumstances. It talks about the renegotiation. Renegotiation would mean formation of a new contract or a new deal to accommodate the unforeseen circumstance. अब unforeseen circumstance has already occurred. Now accommodating that in a contract doesn't make sense, so this is out of context. Let's see option number B. B talks about company A is still obligated to deliver the goods despite the impassable transportation route. अब company A के पास क्या हो गया, इम्पॉसिबल रूट आ गया, तो वो तो डिलीवर कर ही नहीं सकती ना, ये तो फ्रस्ट्रेट हो गया कॉन्ट्रैक्ट, कोई चांस ही नहीं है कि आपकी ऑब्लिगेशन अभी भी रहेगी. सो दिस इज ऑल्सो अ रॉन्ग ऑप्शन. Option number C talks about the contract between company A and B becomes automatically terminated due to frustrating event. Automatic termination is an important provision of frustration. अगर frustrate हो रहा है आपका contract तो it leads to automatic termination that we have already studied. So this is a right option. Let's see option number D. Company A is entitled to seek compensation from B for the losses incurred due to earthquake. अब ये अर्थक्वेक जो है वो एक अनफोर्सीन सर्कमस्टेंस है, इसका लॉस हम कंपनी बी से तो ले ही नहीं सकते, कंपनी बी ले ही नहीं सकती है कंपनी ए से, बिकॉज obviously एक unforeseen circumstances है that was beyond the control of the parties. So this is also a wrong option. Let's see question number 7. Question number 7 talks about company X and Y entered into a contract for the construction of a new office building. After the contract was signed, a new government regulation was introduced. अब इसमें क्या हुआ, एक new government regulation आ गया, prohibiting the use of certain construction materials specified in the contract. This regulation significantly increases the cost of construction and makes it financially unviable for company X to produce. Which of the following options correctly applies the concept of frustration of contract based on the information provided? Now let's see options. Option number A says company X must proceed with the construction despite the increased cost due to the government regulation. अब गवर्नमेंट रेगुलेशन एक अनफोर्सीन सर्कमस्टेंस है और एक ये बियॉन्ड द कंट्रोल ऑफ पार्टीज है. सो अगर ये हुआ है तो we cannot just proceed without acknowledging this fact. So this is a wrong option. Let's see option number B, that talks about company X can terminate the contract due to the introduction of new government regulation. It puts the right on company X that because it is in a compromising situation, it can terminate the contract due to new government regulation. This is a right option because the contract can be terminated on the basis of new government regulation because it is an unforeseen circumstances. Now let's see option number C. C talks about company X can renegotiate the contract terms with Y to share the increased construction cost. This is not the point of discussion because due to unforeseen circumstance, the concept of frustration of contract will be applied and renegotiation would not change the situation. Option number D talks about company X can seek compensation from the government for the financial losses incurred due to the new regulation. It can seek financial losses from the government, but it won't be covered as a breach of contract on the part of government. It is just a loss which can be covered from government under other suit. It cannot be covered as a concept of frustration of contract. So this is also a wrong option. Let's see question number 8. Question number 8 talks about company P and Q entered into a contract for the provision of marketing services. So here the services will be marketing services. However, before the contract could be fulfilled, a worldwide pandemic erupted, causing strict lockdown measures and prohibiting gatherings. As a result, company Q was unable to organize the marketing event as originally planned. Which of the following option correctly applies the construction concept of frustration of contract based on the information provided? Let's see option number A. Company P can sue Q for breach of contract due to the inability of organizing the market events. अब इसमें inability of company Q तो अनफोर्सीन सर्कमस्टांस की वजह से आई है ना, तो इसमें ब्रीच ऑफ कॉन्ट्रैक्ट तो कहीं हो ही नहीं रही है, तो फ्रस्ट्रेशन ऑफ कॉन्ट्रैक्ट का केस है. सो दिस इज अ रॉन्ग ऑप्शन. लेट्स सी ऑप्शन नंबर बी. Company Q must find an alternative ways to fulfill the contract despite the lockdown measure. Finding an alternative way is not possible because unforeseen circumstance आ गया है जिसकी वजह से contract frustrate हो गया है. So this is also a wrong option. Let's see option number C. The contract between P and Q becomes automatically terminated due to the frustrating event. Again, automatic termination is a key concept of frustration of contract, and in this case, imposing of lockdown is an unforeseen circumstance leading to frustration of contract, leading to automatic termination. So this is a right option. Let's see option number D. Company P is required to compensate Q for the losses incurred during the pandemic. All the companies has to bear their own losses. It cannot ask for the compensation from the other party. This is a wrong option. Let's see your question number 9. It talks about company M and N entered into a contract for the sale of unique piece of artwork. After the contract was signed, a certain fire broke out in company N. फायर ब्रोक आउट हुई कंपनी एन में जिस वजह से डिस्ट्रॉय हो गया आर्टवर्क. which lead to the following options correctly applies the concept of frustration based on the information provided. Let's see. Option number 8 talks about company N is obligated to deliver the artwork despite the fire incident. भाई आर्टवर्क तो ऑलरेडी फायर में डिस्ट्रॉय हो गया है एंड फायर तो एक अनफोर्सीन सर्कमस्टेंस है, तो अब ऑब्लिगेशन तो अराइज ही नहीं हो रहा है डिलीवरी का, क्योंकि पहली बात तो गुड डिस्ट्रॉय हो गया है, दूसरी बात वो अनफोर्सीन सर्कमस्टेंस की वजह से हुआ है. So this is a wrong option. Let's see option number B. Company M can terminate the contract due to the destruction of the artwork. अब भाई कंपनी M टर्मिनेट तो कर सकती है कॉन्ट्रैक्ट, क्योंकि डिस्ट्रक्शन ऑफ आर्टवर्क हो गया है, जिसकी वजह से किसकी वजह से हुआ है, वो हुआ है फायर की वजह से, और जो फायर है वो एक अनफोर्सीन सर्कमस्टेंस है एंड अनफोर्सीन सर्कमस्टेंस गिव्स द पावर ऑफ टर्मिनेशन. So this is a right option. Let's see option number C. Company M can demand a replacement artwork of equal value from the company N. This is also a wrong option because it has lead to the frustration of the contract. Compensation or replacement is secondary. Now let's talk about D. Company N is responsible for compensating M for the loss of the artwork. It is not the case of compensation because the destruction has been caused due to a unforeseen circumstance. This is also a wrong option. Let's see the last question. Question number 10. Company X and Y entered into a contract for the supply of raw materials. However, due to sudden surge in demand and limited availability of raw materials in the market, the price of the materials increased significantly. अब इसमें क्या है, डिमांड की बात की गई है और रॉ मटेरियल्स की अवेलेबिलिटी की बात की गई है, जिस वजह से प्राइस बहुत सिग्निफिकेंटली इंक्रीज हो गया है. Company X, the supplier, now insists on renegotiating the price of the contract. Which of the following option correctly applies the concept of frustration of contract based on the information provided? Let's see options. Option number A talks about company X must accept the price renegotiation proposed by the company Y to ensure a steady supply of raw materials. Renegotiation is not possible as it has been led to the frustration of contract. Wrong option. Option number B talks about company Y is obligated to supply the raw materials at the original agreed price despite the market conditions. अब मार्केट कंडीशंस क्या एक अनफोर्सीन सर्कमस्टेंस है जिससे हम फ्रस्ट्रेशन ऑफ कॉन्ट्रैक्ट मान सकते हैं. अब ऐसे तो भाई अगर आज मैं कॉन्ट्रैक्ट करती हूँ किसी से कि आई नीड XYZ प्रोडक्ट्स फॉर XYZ अमाउंट, और ड्यू टू सम मार्केट फोर्सेस वो XYZ अमाउंट इज नाउ नॉट अप्रोप्रिएट फॉर द XYZ प्रोडक्ट्स, तो इसका मतलब ये तो नहीं है कि मेरा कॉन्ट्रैक्ट फ्रस्ट्रेट हो गया. कॉन्ट्रैक्ट तो मैंने जब किया था तब दोनों पार्टीज का कंसेंट था, दोनों पार्टीज ने वो प्राइस के लिए हाँ बोला था. तो अब जस्ट बिकॉज मार्केट फोर्सेस की वजह से डिमांड और सप्लाई इधर उधर हो गया और प्राइस बढ़ गई है इज नॉट अ appropriate reason leading to the frustration of contract. So this is a right option. The company Y has a obligation and it has to deliver the products on the original agreed price because the situation illustrated here, that is the market availability and demand leading to the increase in price, is not unforeseen circumstances. The contract between X and Y becomes automatically terminated due to the change in market condition. Automatic termination is only in the case of frustration of contract, and here the market conditions do not lead to unforeseen circumstances, and hence this is a wrong option. Option number D talks about company X can seek compensation from Y for financial losses incurred due to the increased price materials. Obviously not. This is also a wrong option. We have uh, we have studied all the questions. I hope you understood it. Keep studying. All the best.